Yes, Mr. Manage.
May it please the Lords, I appear for EasyGroup, my learned friend Ms. Wickenden, and my learned friends Mr. Van Heegen and Mr. Jordan appear for the defendant parties, or the respondents / cross-appellants. As you will have seen, this is an appeal against the final order of Mrs. Justice Bacon following a trial on trademark infringement. I think the proposal is that I would address my Lords on EasyGroup's three main appeals. So those are revocation, infringement and honest concurrent use. Then my learned friend would respond. That will probably take all or most of the day. And then my learned friend will respond on that. I would have a brief reply, and then he would open his res judicata appeal. And my learned friend, Ms. Wickenden, will be responding to that. And no doubt Mr. Van Heegen will wish a reply then. And then the proposal would be to deal with sort of other issues at that point, because some of them are contingent, some of our consequent appeals are contingent upon my learned friend's points. But as I say, that's the proposal.
Well, we're in the hands of counsel as to what you consider sensible by way of an arrangement of the argument on the issues. The only point that I would make is that I would ask you to bear in mind that we cannot go beyond close of play on Thursday.
Understood.
So it's up to you and Mr. Van Heegen and your respective juniors as to how you distribute the time between you so as to efficiently manage what appears to be a forest of issues.
There are a lot of issues. Fortunately, there's sort of snakes and ladders. There's ways of ruling out some issues. But so far as the revocation issue, strictly speaking, it came second in time because we got permission to appeal from the judge on infringement, and then we appealed on revocation. But it makes sense in my submission to start with the trademark and the effect of the trademark, what is left of the trademark. So
fine. Well, but before you start getting into the substance, the other point I would just raise at this stage is that I've authorised transcripts. I assume those are going to be overnight transcripts, and if so, could I ask that you ensure that they're copied to the members of the court?
Certainly, Mark.
Thank you.
I propose to focus on revocation. There's a degree of interrelationship, but revocation is quite self-contained. There's a couple of issues that are contingent upon it, non-use as a defence and the dates of revocation. But apart from that, it's relatively self-contained. I propose to focus on the main findings in the judgment that we address with our grounds of appeal, and really dip very briefly into the evidence, which I think my Lords will have seen is a self-contained bundle as well, SB2. I'm not going to turn every page of it, but I'll just sort of briefly characterise what it is. And then summarise the main errors we say. We say there are 5 in outline, develop each of those, and then I hope to address my learned friend's responsive points, although I might save that for reply depending on how the time is going. So if my Lords take the judgment in the core bundle at tab 20, the findings in relation to revocation are relatively self-contained as well in the judgment, although subject to one important qualification, which is the point of construction, where we say there was a sort of a cross-pollination between the infringement judgment and the revocation judgment. So if one looks at page core bundle tab 20, page 251, there's a section on revocation on non-use. I'm sure my Lords have read this, but I'm just going to focus on the bits that we say are important for the purposes of the appeal. The judge starts that section with the legal principles. We have a point, unusually we have a point that arises on that. The relevant period is identified in paragraph 261, and that is the 260. It is 261. The first is whether the date on which the claim was filed, 15th of May 2009, there's marks were liable to be revoked on the grounds that they were not genuinely used in the 5 preceding years. So that's the period we're talking about, May 2014 to May 2019. Then we come to quite an important passage, which revolves around the construction point, or the construction issue. And you can see that where the judge frames the two different kinds of use. The first of them is what the judge calls the physical hire. That's in 261. So EasyGroup relies on two types of use during that period. First, the physical hire of Easy Office premises in the Croydon Easy Hotel building. And secondly, white label use through the arrangement with instant officers until January 2019. That's the EasyOffice.co.uk website. And the judge refers to it as the physical hire. It wasn't relied upon as a physical hire, but it was relied upon in relation to premises belonging to EasyGroup. And then when the judge is talking about the Croydon Easy Hotel building, again, that was, we say, not relevant. Secondly, white label use through the arrangement with instant officers, which was described variously as a referral or licensing arrangement. We say it was a licensing arrangement. I think referral was my learned friend's characterization of it. And then just the last sentence of that paragraph is important on the construction. So the arrangement with instant officers is, however, only relevant to the use of EU 376, since the service provided by instant officers, namely a brokerage service, serviced office space, fell outside the specifications for UK 528A and EU 509. It isn't clear from the judgment there whether that's what EasyGroup were alleging or whether the judge is finding that. On closer inspection, it's clear that that is the judge's finding. EasyGroup didn't only rely on instant officers under EU 376. EasyGroup contended that that was use of office rental, hire of temporary office space, as well as the services in EU 376. So I just wanted to clarify that in case the judge is sort of mixing up things, not mixing up, but for the purposes of the summary, talking about things that are relied upon versus things that the judge determined herself. Now, we say at this point it's probably helpful just to quickly turn up the trademarks, which you'll find in SB1, tab 1, page 9. If I just ask you to keep the judgment open, as I'll continue in a moment, but I just wanted to explain how that point arises. Tab 1, you will see from, these are printouts from the UKIPO website, which are sufficient for the purposes of present purposes. The first mark, so to speak, is in fact 4 marks. It's a series of marks. So that comprises a word, easy office, all caps. But that's protection. Word only protection. Word as such protection. The next one is easy office, where there's a capitalization of the O, which I understand is sometimes called the camel capitalization because of the O. And the Easy Office device in colour, and then the Easy Office device or figurative art or stylised word. I'm not sure much turns on what you call it. It is what is as shown. I should just point out that there are 4 marks in the series, and then the applicant claims that there's a mark claim, not a limitation, I should add. The applicant claims the colours orange and white as an element of the 3rd mark in the series. That was applied for in 2002 and achieved registration in 2003. And I just wanted to show you the goods or only services of this mark. Over the page, class 43. Unfortunately, the hole punch has knocked out the first letter, but it's hire of temporary office space. that's what was relied upon in this mark. Hire of temporary office space. The next mark, so there's 4 there. Then there's on the same day, there's an application to achieve registration as an EUTM. And that's again, EasyOffice word as such, mark. And this has got a slightly broader specification. You've got rental of offices in class 36 has been added to the class 43 hire of temporary office space. So it's got a bit more. Rental of offices, hire of temporary office space. I should say just at the outset, we don't make any meaningful distinction between those. We say that those are essentially the same service. It's a matter of almost a matter of chance that it could have been registered under 36 or 43. 36
seems a bit odd. I mean, of course, it's in principle possible to have the same service falling within 2 classes, but the system is designed to try and prevent that.
Yeah, this is an example where the system's imperfections rather come to the fore, because as the Lord knows from Omega and other cases, the NICE classification is far from symmetrical and principled in every respect. In class 36, it's principally financial services with this sort of real estate stuff chucked in there with it as a matter of fortune. But then 43 does have meeting rooms and temporary accommodation. And I think I'm not going to give evidence about this, but given the business model adopted by the EasyGroup, temporary offices, low cost, etc., that it was sort of straddling 43 and 36. But no point has arisen on this, and I don't think there is any particular point to be made on appeal. But the point I wanted to show you was that that's a sort of extension of the services into class 36, which is probably the more conventional class for officers now. Then we come to the EU 376, which is behind tab 3. This is similar, but not exactly the same as the third mark in the series of 528A. And you can see that that was applied for significantly later. The filing date is the 4th of March 2013, and the mark is shown over the page. But the services are considerably expanded here. There's, leaving aside the class 35, on which nothing turns, and looking at 36, there's a number of financial services. Again, nothing turns on those. But it does contain rental of offices and rental of office space. I have to say, I'm not sure what I suppose it's a plurality of offices. And then there are a number of other terms. And it then concludes information services relating to all of the aforesaid services. So information services relating to rental of offices is specifically relied upon in the amended particulars of claim. Then 43, again, that's continued, hire of temporary office space, rental, that's probably all I need from that, hire of temporary office space, and then services, information, ... services for all the aforesaid services. So information services for the hire of temporary office space. So this one has the same as the other EU mark, but 2 extra services. The point I was going to make about there's a slight point about hire versus rent made in my learned friend Skeleton, that we somehow conceded that we didn't hire, we only rented. That's not right. I can take my laws to it, but as we pointed out in our respondent skeleton, the SB1, tab 4, page 25, we said that it's common in English to use hire and rent interchangeably. Avis car hire, Avis car rent. And although strictly speaking they might have a different dictionary meaning, they are, as a matter of consumer understanding and perception, to all intents and purposes, the same. The actually that was the reference I gave you, SB1 or 25. It's wrong. I think it's core bundle 16160. Thanks. Okay. So just to return to the judgment, the judge is construing the instant officers. It's a little bit unclear that why it's not falling within the services of all three marks, but only relevant to the use of EU 376. But I hope, since we looked at the marks, that by process of elimination can only be because EU 376 covers the information services relating to office rental and temporary hire. And we can see that because at the end of that paragraph, the judge says, I address the specifications of the marks in more detail below in my discussion of infringement, and indeed does so at 299 and 301, which I'll delve into a bit later. And one can see from there the reasoning. It's a bit unusual because this is the first time we encounter the point in the judgment, but it's sort of cross-referring forward rather than cross-referring backwards, and no particular criticism is made of that. So that's sort of where the construction point happens. The result of that is that Croydon and instant officers are sort of separated or siloed from each other and don't get to reinforce each other. When we say right off the bat that is artificial, given that Croydon was advertised on the EasyOffice's site, and indeed all of the other physical premises that were part of the EasyOffice empire in its heyday were advertised on that site. But actually, there's a more sweeping finding, not to give away the end of the story, but of course the judge completely discounted Croydon and also completely discounted instant officers, so that effectively we had the use was trimmed back in relation to the first two marks that I showed you back to December 2012, before Croydon existed, and instant officers was, as I say, left out of account completely. So just in relation to the particular, findings on Croydon, those are contained at 263 to 271, and there are a number of points there which the judge makes about the low number of bookings, the paucity of customers, the low revenue figures, the marketing activity, the Google AdWords spend being desultory, and the direct email marketing campaign to hundreds of customers, and getting responses from those customers was also desultory. The only, there was fly posting as well, 1,000 flyers in October 2013, which was a few months before the period, and a further 5,000 flyers in January 2014, which was 4 months before the relevant period. Again, that was considered not to be genuine use overall. Now, the judge also reaches quite an important finding at 270, which is just at the beginning of that section. My learned friend submitted robustly at trial in written and oral submission that this was all sham. This was token, as it's called in the European case law, token use designed to maintain trademark rights, not a genuine commercial, legitimate business. And the cross-examination of Sir Stelios was quite extensive and aimed at supporting that contention. Now, the judge was critical of Sir Stelios in the judgment, and came to the conclusion that she would place very little weight on his evidence except where it was corroborated. The material I will show you is clearly corroborating it. This was quite some time ago, and the judge fairly, say, acknowledged that it was, he couldn't remember very much. But most importantly, in 270, the judge does not go on to find that this was sham use. And that's quite an important finding, because if you have extensive use that's sham, it's still not genuine. Let's put in mind the merit case. I don't know if you'll recall that one, where the cigarette company had sold extensive amounts of merit cigarettes, but it was all sham. It was all designed to increase the monopoly of merit. At least that's how I'm recording the report. But that is quite an important point. It was an important submission from Learned Friend. Now the judge says that she doesn't need to go that far, and then finds that the use not sufficient for genuine use. The position in relation to the instant officers arrangement is 272 and down to 277. Essentially, the judge finds a series of issues with the evidence that we say are not asking the correct question of what the evidence shows at all. So we're not challenging the factual findings in relation to any of this. We simply say that taking the evidence at face value, if the tribunal had been asking the correct question, then there was more than sufficient basis for a finding of genuine use. At 283, the judge finally concludes that there is no genuine use in the period, in either respect, and then the dates of revocation are 285 to 286. So the EU mark is trimmed back to its rump, so to speak, because it's got the later period of registration. 5 years after it hits the register, it is revoked, as if it has never been used, which we find quite surprising, given the judge herself has found that the instant officers' use was information services. But then, so far as the earlier marks are concerned, those are taken back to a date that the judge held to be the right date. I think the Learned Friend wanted to take it back further, indeed, even within the period of registration, 5-year period following registration. But the judge takes it back to December 2017 on the basis that the last use that she's confident of is December 2012 at Old Street. So that's the effect. We then have, I just wanted to show you very briefly what the material shows, and again I'm going to try and just basically show what the material shows without suggesting in any way that it shows something different to what the judge said, provided it is taken in the context of the right question. So if you take bundle SB2, and this is in sort of thematic order, rather than, I think, strictly chronological. So you'll have to forgive me if it's a certain amount of jumping around. So the first tab is the easy.com, sorry, tab 2, is the easy.com website. And that's the sort of family of brands website, which contains a number of the EasyGroup businesses, and EasyOffice is mentioned there. It's fair to say not much turns on that, because it doesn't actually show the use of the mark in terms of the actual type of business it is, but it is a modest and fairly vague advertising use. Then we come to the specific EasyOffice.co.uk website. Now, these, I believe, are largely in chronological order, although we pop back in time in the middle. And the point I would make about these is, if you look at tab 3, office space to rent, that strapline is there in, well, 2013, on the 16th of February 2013. In fact, it's been there a lot longer than that, but never mind. The purposes of the relevant period. And that is we say quite important in terms of the consumer understanding of what this is. There is no mention of any brokerage or anything of that nature, and I'll come back to that. There's a message from Stelios, and actually if you turn forward a few pages, you can see that actually has a photograph. If one goes to page 31, and that's on the 7th of August 2013, a message from Stelios, EasyOffice, chairman and founder of Stelios. So this is presented as part of the Stelios Easy group of companies. On the right-hand side of that this is outside the relevant period, but I rely on it nonetheless, because we say the judge penalised us for the use before the period, when in fact that favoured us. But I'll come back to that. The office locations, you can see Old Street and Wimbledon are mentioned there. Those are the physical premises, and below that, new office space opening up at Croydon. And you've got below that instant quote and book, need more locations in the middle. We can search over 500 London business centres. And the overarching slogan, office space to rent, and irresistibly, Easy Pizza is cross-promoted at the bottom. So we say, in relation to that there is, and obviously I'll be dealing with this in the grounds of appeal, that's an advertising use. Advertising of what? Advertising of office rental, advertising of the hire of temporary office space, and we say it is information services in relation to office rental and hire of temporary offices. It's common ground that this site was up for many years, let us say more than a decade. I believe it was referred to in the W3 case by my Lord Justice Arnold, sitting at first instance. And this is the EasyOffice website for a web-based business. That's the entire USP, so to speak, of the Easy brand. There are emails in this bundle where somebody tries to telephone Croydon and they're told, can you email? Sort of, there's not a great enthusiasm for the old way of doing things. This is an internet-based business, and that's part of its USP. But we also say that just looking at it in terms of the genuineness of the business, this is linked to the home page, the Easy page. It has got Stelios' name on it. It is clearly the Easy Group making itself responsible for it. Any member of the public, or SME, or larger business looking to rent office space knows nothing of what lies behind this site. Now, what does lie behind, as a matter of fact, is Instant Offices, who are a web broker, who've got a booking engine, and the judge correctly said, my learned friend was advancing this very strongly, that there wasn't a great deal of information about how the transactions worked, and there wasn't a great deal of information about who answered the phone, and there's a phone number there, or much at all from Instant Offices. But there was some, and I wanted to show you that in due course. So just to look through these pages, they pretty much stay the same. You can see, just taking page 40, which is February 2015. This is after the relevant. Sorry, this is within the relevant period, so after the period started. And office space to rent. Our office locations. By this time, Croydon was established, and so it's not.
I beg your pardon. Could you give me the page again?
I'm sorry, Lord. It's page 40.
Thank you.
And that's our office locations, and you can see Old Street and Wimbledon are now gone. That's right, they closed. But to all intents, and Croydon is now not listed as a new, coming soon. It is now established, and you've got, to all intents and purposes, the same site in every other respect. Just to, I don't want to, not too long, but just what happens with this is Eventually, in January 2009, this is rebranded effectively as EasyHub. But I wanted to show you one other thing, which is the global office space. Now, page 60, you can see that there is space.
Sorry, when did you say it was rebranded EasyHub?
EasyHub. Oh, I sort of jumped ahead of myself in the story there. I will come back to that. But essentially what happened was...
Just the date.
That's 2019, January 2019.
2019.
Yeah, right. What happened, what I wanted to just show, my lords, was in this part of the website, there is reference to, you can see the little button that says View All UK Office Space, it says in the top left on page 60. And then it's got global office space, Europe, Australia, USA, Asia. I think a point is made on the other side that that's somehow irrelevant. We don't agree with that because, of course, that is directed to the UK public, and therefore it is an advertising use, even in relation to the foreign office provider, so to speak, for reasons I'll come to, and I hope you're aware of from Skeleton, the Standard International case. So what happens, as I say, is that eventually is the arrangement with instant officers comes to an end. Now, there is no doubt that there was an arrangement with instant officers. I mean, just to give you an example, the very last document in this bundle is an email from Andrea Burke-Shaw of Instant Officers addressed to EasyGroup. It was good to catch up with you yesterday. As I mentioned during our call, I wanted to discuss our partnership and ways in which we could increase lead volume and revenue. And essentially, she suggests that while you have access to the data via the white label iframe, there is also an opportunity to drive more traffic to your site using our data feed. So there's clearly an arrangement. This is, of course, there's use of a trademark when it's used not just by the proprietor, but by the proprietor, by someone else with the proprietor's consent. Now, there's a lot of emails in the next tab. Sorry, when I say the next tab, I meant the one after the websites. And those are essentially expressions of interest, correspondence, and so on with customers, members of the public. Now, one can see from the very first one that's there, which is, I won't read out any names, at page 72, that is an individual who has clicked oldstreet@easyoffice.co.uk, email us form submitted. So that's a form on the website that is then, he actually refers to having done that. We're interested in acquiring some office space in Croydon and would like further details on your new site. Costs and services available from time, date, location, Croydon. And there are a number of these. I'm not going to read them all out. But there are a number of a number of forms that are clicked and then the information arrives. And then there's outgoing correspondence. If you turn to page 76, that was, so we had expressions of interest even prior to the Croydon office opening. Then, and these are just an impressionistic material. We turn to page 89. This now is in January 2014, which again is not quite within the period, but as I say, we rely on the continuum of use, not only for the couple of months before, but we also rely upon the general business of the EasyOffice brand, which I'll mention when I come to that ground. It was a very successful brand, very popular, with lots of high street premises, and there was also the background to it was that when the Easy Internet Cafe business, which you may recall, the one in Tottenham Court Road, not least, when people started adopting home internet around that time, all these leases had to be either exploited or got out of, and that came up, Stelios came up with the idea of doing office space, and that's sort of the background to it. But the position here is we had people requesting information before it had come out, and then we come to March, people viewing the space, page 106. And then when we come to May, it just continues. It's all of a piece. There are people clicking on the form. So far as Old Street is concerned, if you look at something like page 130, what is
so? Just to what extent do you rely upon? I mean, I'm looking at 106.
106, yeah.
And obviously there's the inquiry that's come in. And then the response at 1326.54. Note, should you wish to book office space, it needs to be done via the website.
Yes. Yes, that was the point I was sort of talking about. We do highlight I mean, it's the same with EasyJet, to be honest. I mean, you can call EasyJet, but you are encouraged, let us say, to use the website for everything. Actually, a lot of businesses are like that these days, aren't they? But so far as this time is concerned, yes, it was about going through the website, because that was the website was offering not just the instant officers database and booking facility, it was offering clickable links to the Old Street, Wimbledon, and various other places. And by this time,
in this case, it's Croydon.
Good, yeah. So what happens now is, of course, we get into the use period, and we say that that's all continuous. There's any real distinction, and so that's one of the reasons why I should make the submission, which is that although strictly speaking I've got a burden to show use during the period, evidence before and even after the period, especially if it's along a continuum, can have relevance to assessing the use that's made during the period. And so we say that's the case here. We engaged in a specific mail shot campaign to customers at Old Street, because we basically said, look, Old Street's closing. Would you like to come down to Croydon and rent an office there? And some of these are responses to that. The judge referred to that in the judgment. Some more of those. Then I think what I'll do is I'll leave that tab for the moment. The Lords have got. There's a bit more pricing information on 147. Desks cost as little as £4 per day. This might have a slight relevance to my learned friend's submission about the highly circumspect, sophisticated business consumer that he says is the average consumer when it comes to the infringement question. So far as the next tab is concerned, this is the EasyOffice Old Street notice that I was just referring to. So tab 6 rather. I'm writing to give you formal notice of our intention to stop taking bookings. 2 floors of the Easy Hotel house will be converted into hotel rooms, Easy Hotel. For those customers who wish to stay part of the family, our Easy Office family, we'd be happy to welcome you to our new Croydon building, where office space can be rented. And we see that is the text. We also see, by the way, on the next page, so Stelios involved in that. He suggests some changes to the text, to the price. And as I say, there were some responses. The next tab is a flyer. Now this is, I think 5,000 of these were sent out in January 14. Strictly speaking, 4 months before the relevant period. Out of scope, say the defendants, irrelevant. We disagree. We say that this is part of all the facts and circumstances that go into the assessment of genuine use in relation to Croydon, but also part of the continuum. When somebody has a flyer, advertising doesn't just simply dissipate in one day. Someone might keep this on their, keep it in their wallet or keep it on their windowsill if they want to get some Croydon space. There's no doubt about this having been distributed, by the way, because at page 182 you can see there's a purchase order from, and it refers to the distribution of the flyers in Croydon, printing of 5,085 leaflets, and the cost of that. It's signed off by Stelios. Now the next part is a somewhat controversial part of the judgment, where the judge suggests that there's some sort of learned friend also very much suggested that there was something, well, it was sham, partly because there were a number of test bookings by the EasyGroup staff. As you'll see from the correspondence, that's a perfectly normal thing to do when they set up a new office or set up a new piece of software. But in those, of course, there were, and there was no attempt to hide this, by the way, this was all open, and then there were a number of rentals. Now the judge considered that the number was too small. I have to address you on that. We say that's not the right approach. And then there's some emails in the next tab. Quite a lot of the next tab relates to the refurbishment. But again, there's nothing controversial about this. The judge herself noted that the original suite of offices were open plan and on the ground floor. And then they were turned into private offices on the second floor. And that was an attempt, we say, the judge didn't find this, didn't consider it, it seems. We say that was an attempt to improve the commercial fate of the business then. Didn't work, and unfortunately it didn't result in further bookings. But so far as the attempt was concerned, it was legitimate. And a lot of the email correspondence relates to they had to have a certain amount of space between the wall and the ceiling for ventilation and Wi-Fi and so on. So I wasn't proposing to go much more. Just to show you, just on that point about test bookings, 214 behind tab 17. So once we had refurbished the second floor, there's an email from Stavros, who's the Stelios' man in charge of this particular operation. Hi Stelios, the inventory and pricing has been loaded and a test booking has been made. 14 officers. Sorry it's taken so long, the parameters in the back office need to be changed.
Sorry, which page you on?
I'm sorry, 214, my lord.
Thank you.
That's sort of the context for test booking. When things get set up, they've got to test the system. It's an online system. There's quite a lot of surrounding email which makes it very clear what was what was going on. The next tab is 19. Now this is interesting because the judge described Google AdWords campaign, or indeed all the marketing in relation to Croydon and presumably in relation to Croydon only, sorry, as desultory. And I mean, that itself is a word of quantification for a start. It's a quantitative word. It is too low, insultingly low, maybe. But it is a word of quantification, and the judge was aware of the AdWords campaign, was aware that there were £2,000 spent over 2 months, and that was within the period. And you can see some discussion between Stavros and Stelios about what it's likely to achieve. AdWords, as I'm sure my lords are aware, is when you bid on search terms that consumers are going to be carrying out, for example, office space London or office Croydon, whatever it might be, and you get your link, your ad link, which will be easyoffice.co.uk, in front of their eyeballs. And there is clear evidence in this that we paid that and that we achieved an unfortunately low number of clicks, sometimes called conversions, I think. But on page 240, you can see overall the ads have appeared in the middle of the page. See 11,000 times on search results, and there have been 30 clicks on them. It's a volume business, it was clearly, but the site is coming up in response to people specifically looking for office space. Now, we don't have, my own friend I'm sure is going to point out, we don't have a lot of detail about the 30 clicks or what happened next, or indeed the add text. But one thing one can be very sure of is that it contained EasyOffice.co.uk, because we don't have any other site, so there wouldn't have been any other link that would have been provided. So we say it's a reasonable inference. Then, if you turn to the next tab, 20, this is discussing the homepage booking engine at EasyOffice.co.uk, and it's talking about Croydon input into that website, EasyOffice banner, and so on. If you see over the page 242, can we come up with a banner to replace the one we put when EasyOffice Croydon first opened attached? Let's focus on having some text which conveys info that's not visible on the homepage, otherwise something like EasyOffice Croydon office space from £40 per week, and then link it to this and that. So these are efforts to improve the advertising and promotion. There are pictures of the premises in tab 22. The only significance of that is that this building that was acquired by EasyGroup was already an office building, which made it suitable for reasonable occupancy by temporary offices, although it wasn't only devoted to that. 22 is a series of rather out-of-date news stories on the EasyOffice.co.uk site. My learned friend makes a point that that is shows that this was not visited, or somehow that it wasn't real. We venture that people are not visiting the EasyOffice.co.uk website to read news stories, but of course, like every website, it has some out-of-date ones, quite like my Chamber's website. EasyOffice.co.uk, there's more pictures of the website, which I don't think I need to take forwards to at the next tab. But then 24 are some invoices. Now, there's no question that these are authentic. These were authentic documents. These were admitted documents. Certain points were made about the weight, given that the person speaking to them. But my submission, these are classic evidence that one submits in proceedings of this kind for the judge. It's an EasyGroup invoice addressed into instant officers, and it's EasyOffice fee report. So it is entirely consistent with what has always been asserted by EasyGroup. And there are a number of them. They're not a complete list there, but the next tab also contains some more. And so it can't be denied, we suggest, that this arrangement existed and was producing commission payments from instant officers to EasyGroup. And one can't simply say this is small for the following reasons. Brokerage works on a 10% commission of the price of the rental. But EasyGroup, because of this white label arrangement, were getting a portion of that again. So it's not really a safe guide to the size of the business to say £271 on page 285 in 17th of October 2016. That's trivial because it is it's a commission upon a commission. The other point that my learned friend was very successful for the judge in raising was the inconsistencies between statements of commission. And it said these were all consistent with each other. There was no idea where they came from, and they were internally produced. And it's fair to say that some of those criticisms were justified in the sense that we didn't have a witness saying, I produced this document by checking all the invoices and so on. But read together with the other material, isn't hard to accept that this material is a reasonable snapshot of the invoice amounts. One can see they're of that sort of order. But we make a further point that although it was said that these were inconsistent, this particular fee statement at 25 and the other one, which is at, I believe, yes, at the 27, in fact, they don't cover the exact period. It depends how much of the income is attributable to 2014. Now, it's absolutely fair to take that on the chin and say, well, burden's on me, and I should have clarified that, and I accept that for sure. But the point is that it isn't about whether we achieved, £20,000 worth of commission on commission income or 18,000. I mean, if there's 10,000, it's simply not the overarching consideration. But what's also, we say, interesting about this is that if you look at the actual entries, you can see that these are for an array of, especially the second batch, which you'll find at, where's it start? Sorry, 304 of tab 27. I mean, my learned friend did the usual, absolutely legitimate thing of, going over this with a fine-tooth comb, and we accept that. But some of the criticisms seem to be exaggerated in the end, because there's clear reference to a large number of different office providers, including Regis. One can see on the very first entry a number of Regis offices. Much was made of the column that says, so you've got, the column at the top, so you've got operator, user company, date, paid, and it said false, as if that's some sort of pejorative word. Well, it's just, the column is whether it was paid or not. Was it paid or not? False, it wasn't paid. True, it wasn't paid. I mean, that is the kind of thing that we say was an exaggerated criticism, and it makes its way into the judgment. And what we didn't have, we say, is really a standing back and considering what was going on with instant officers. Of course, we have the construction error, we say, at the beginning, which is that the judge effectively siloed this anyway away from Croydon, whereas we say this was at least in part the same service as Croydon being promoted and advertised. Certainly another service that fell within office rental and temporary hire of office space. And certainly, again, use of information services in relation to temporary hire and rental of offices and temporary hire of office space. And so at that point, the question was, taking into account all the facts and matters, all the relevant considerations, was there a desire to create and maintain a market share? Was this consistent with the essential function and the other points that are necessary to establish? And for that, on that basis, we say the material was certainly, we say, good enough. I wanted to now just show you summarise the...
Yes, just on that, can you help me on this? I was looking at the judge's order, which is Core Bundle tab 23, page 284.
Yes.
And just taking EU 509 as illustration. So that is revoked with effect from 31st December 2017 in relation to rental of offices, hire of temporary office space. Just yes. Focus on those two for the moment, but not with regard to information services.
I think the problem was
Is that because it comes in at 376?
It comes in at 376, correct?
Only 376.
It's only 376 that has it. But I'm anticipating that my lord may be going in another point, which is, of course, there were other services in some of these marks that weren't revoked. And that was as a result of the post-trial hearing, where there was an argument about whether the defendants had properly put in issue those services. But yes, in relation to 376, the answer is a relatively simple one. That is the only mark that has information.
Right, and there the revocation is from the later date of 31st July
Yes.
2018.
As if there were never any use, because that's the earliest you can go back. Although
Right.
I think there's a suggestion that you can go back further. That's persistent. Right. So I was going to then show Lords or summarise what we say are the sort of 5 main errors. We say in outline that the first error was the judge wrongly held in terms that it's well established that the existence of some retail sales is not itself sufficient to show genuine use. And in holding that, she followed the Board of Appeal, it appears, in the Reba case, but that's a second order criticism. The main criticism is that this is finding that some retail sales is not sufficient. We say that's wrong. Second error was wrongly construing the specified services of the marks, and thus wrongly holding that brokerage, i.e. the instant officers arrangement, was outside rental and hire of the space, temporary office space. And also the effect of that was to separate or compartmentalise the two principal streams of evidence of use or activity. The third error was, we say, failing to take account of the use of the mark in advertising, especially with regard to the EasyOffice website, which had been live and active as a means of attracting custom for office rental for over a decade by the time of the trial. And the fourth error, we say, is errors regarding the significance of the characteristics of the proprietor. It is well established that you take into account the characteristics of the proprietor, but the judge penalised the proprietor for its previous success. This is a bit of trying to encapsulate this in a short form for my lords. It is essentially wrongly penalising the proprietor for previous success and failing to acknowledge that that made genuine use more, not less likely. And the final error, we say, relates to information services. The judge, on any view, should have held that mark EU 376 stood for information services relating to rental of offices. And there was no warrant for asking in relation to that or the advertising use what the significance was of the transactions underneath, or how much detail there was in relation to what instant officers were doing and who was answering the phone. Now, if I can just develop those points. The judge's first error comes in her summary of the relevant principles. You take that part of the judgment as the 251 is the introduction, and then 252 of the judgment, tab 20, is it's uncontroversial that a trademark proprietor bears the burden of proving genuine use. We agree, and we say we did. And then the judge mentions the decision of Mr. Alexander, QC, sitting as the appointed person, about the importance of evidence. Again, it's very difficult to see how you're going to win in a revocation case as the proprietor unless you put in evidence, and it's got to be clear, precise, detailed, and well supported. We say we had all of that, and Contradistinction is, in 22, if you do little or nothing, and you, for example, just rely on your witness statement, and maybe an invoice, you're going to be in trouble. And really, that's all Mr. Alexander is saying. 253, again, we agree with these principles. These are the policy underpinnings for revocation, being that it's important that monopolies should not extend to areas in which the proprietor is not genuinely active. Mr. Justice Floyd, as there was in Galileo. The principles adopted by the European Court of genuine use were summarised by my Lord Justice Arnold in London Taxi. I thought I might just pull that out because there's a bit of passage. There's a passage around that of some use as well. That's Authorities Bundle 4, tab 40. And this is only an extract from the judgment because the various points on the shape of like the taxis and so on are not for us today. The use of the CTM, you can see in the sideline passage on 217. There's a number of cases, and this summary of the law seems to have really started by Ms. Carboni in the Sicilia case that's referred to, but then it's adopted and it's made its way through and had a few other bits bolted on, and it's ended up as the summary here, and it, in fact, now has become very much a commonly cited summary of the law. 219, it probably is all my lords need to read on this as an up-to-date position. The only thing it's not really covering, which is perhaps of very, very peripheral relevance, is principle of partial revocation and the recent case law in that regard. But that doesn't arise in this case, strictly speaking, although there was some discussion of it at the trial. Genuine use means actual use of the trademark by the proprietor or by a third party with authority to use the mark. There was a finding here that there was no copy of the contract with instant officers. No one could recall whether there was a contract. It certainly couldn't be found. The arrangement had been in place for well over a decade, and this was not the most, shall we say, complex arrangement.
We don't know.
Well, we can see by the sums involved in the correspondence with instant officers, which just say, here's the invoice, here's the amount, so. So what we have is the authority of the party to use it. We do say that in effect that was instant officers' use by way of managing the site, that it's perfectly possible and proper. The use must be more than merely token, that is to say, serving solely to preserve the rights. Token is an odd word. The English word was sham under the old law, and I think we all know what that means. It seems to be a slightly more accurate word, but that is what is meant by the second principle. The use must be consistent with the essential function of the mark, which is to guarantee the identity of the origin of the goods. Now that is, I think, common ground, that the use, if it were genuine use, is consistent. It's trademark use, it's used to indicate origin. Use of a mark must relate to goods or services which are already marketed or which are about to be marketed and for which preparations to secure customers are underway, particularly in the form of advertising campaigns. That's significant because it seems that even in the Ansell case, it was already clear that advertising use, absent sales, or with an advertising campaign, preparations to secure customers could amount to genuine use. Internal use by the proprietor doesn't suffice, and nor does distribution of purely promotional items as a reward for the purchase of other goods. And probably the key part of the test is the next part, 5. The use must be by way of real commercial exploitation of the mark on the market for the relevant goods or services. That is to say, use in accordance with the commercial raison d'etre of the mark, which is to create or preserve an outlet for the goods or services. Create or preserve we say, are important words, and it's got to be use in accordance with. So it is fundamentally, it's a qualitative exercise that is being embarked upon to some extent, which is that, is this the kind of use that is consistent with creating, which would be at the beginning of a lifespan of a trademark perhaps, or preserving an outlet. There is notably no requirement for having achieved a particular market share in that passage. All the relevant facts, and this is very important as well, in fact most of the cases I would suggest turn on paragraph 6, all the relevant facts and circumstances must be taken into account in determining whether there's a real commercial exploitation of the mark. And then there's a list, non-exhaustively, whether it's viewed as warranted in the economic sector, and that's a sort of objective test to maintain or create a share. The nature of the goods, scale and frequency, whether it's used for marketing all the goods or some, and any other evidence that the proprietor is able to provide. Territorial extent. Now, the reason we say that's important is because what's that saying is that you don't have no trump cards are allowed. You can't say, because I've shown this, I win, or you can't say, because you showed only that, you lose. It doesn't work like that. It's a multifactorial test based upon all of the relevant facts and circumstances. And as I hope I'll show you in a moment, the judge, we say, didn't apply that. Essentially, the judge did impose a quantitative test in direct contravention of that principle, but also in contravention of 7, the following one. Use of the mark need not always be quantitatively significant for it to be deemed genuine. Even minimal use may qualify as genuine if it's deemed to be justified in the economic sector for the purpose of creating or preserving market share for the relevant goods. And in fact, there's specific reference to the fact in Lemaire, which I'll be looking at in a moment. Use of a mark by a single client which imports the relevant goods can be sufficient to demonstrate that such use is genuine, if it appears that the import operation has a genuine commercial justification for the proprietor. Thus, there's no de minimis rule. And then, very importantly, the final one, it's not the case that every proven commercial use of the mark may be automatically deemed to constitute genuine use. We agree entirely with that. We're not challenging that. That, as I'll show you now, is a very specific proposition that does not arise in this case and that was misunderstood or misapplied by the judge. So if I could show you the Reba case. Sorry, keeping the judgment open. Sorry, if you haven't put it away. The judgment, after having recited those principles from...
I thought you were going to Reba next.
Yes, I am, which I'll give you a reference to, which is Authorities 6 bundle, tab 61. And then if one keeps the judgment open, it's important to see the distinction that's being made. So, paragraph 256, having recited those principles, the judge says it's well established that the existence of some retail sales of a product is not itself sufficient to demonstrate genuine use of a trademark. We say that's wrong. It's not well established that some retail sales are not themselves sufficient to show genuine use. Some retail sales may be sufficient to show genuine use. It's not the same proposition as in Reba and is incorrect as a statement of the law. The true position is that it may be enough. It's still got to be genuine use. It's not determinative whether merely having some retail sales is genuine use. The correct proposition is permissive, which is that it may be that some retail sales are enough in any particular case, depending on whether it is genuine or not. And it is true that it's not automatically enough. If I could try and reduce that, it is not a case of some sales I win, but that's not the same as saying some sales I lose. And that essentially was the error made on this point.
Sorry, you lost me about 5 minutes ago, Mr. Malinich.
It is.
Paragraph 256,
Yes.
the judge says it's well established the existence of some retail sales of a product is not itself sufficient to demonstrate genuine use.
Yes.
It's saying it's automatically enough.
I'm saying it may be in a particular case. That what that's saying is some sales, if one considers the word some to be some small level of sales, so it's well established that some small level of sales is not sufficient to demonstrate genuine use.
In itself.
In itself, yes, exactly. Now it might be all the court has, it might be all the tribunal has, and taking account of the absence of other factors, it might think that is sufficient.
Are you saying the judge saying it's automatically sufficient?
Automatically insufficient is what I think I am saying the judge said. Whereas some sales, some small sales, are not sufficient. And in fact, if you look at the judgment, you can see that does populate some of the findings. The advertising is too small to count. The amount of bookings, too small to count. Everything is quantitatively assessed. And then, of course, there's the comparison with how we were back in the heyday. So this isn't, in my submission, just a point on language. It really does inform the approach. It is a difficult point, I accept that, and it's also difficult on this side of the court sometimes to understand what it is by what they say in Lemaire and so on. But I hope the answer could be provided if you look at REBA. Let me just take that.
Presumably you want us to look at the English version of
Yes.
61.
We'd be a little lost with the German one, I'm afraid.
Can I just understand?
Yes.
You wouldn't quibble with what the judge said in 256. Instead of saying is not itself sufficient, she'd said is not automatically sufficient.
Yes, I wouldn't quibble with that, because of course the case that I'll show you now is essentially saying that proposition, which is you cannot come into court and say, I have shown some commercial use,
That's
and
enough.
therefore automatically I win. You cannot. And that was all REBA says. REBA just, you had a...
So to be sure I've understood your submission,
Yep.
you say that that's the true proposition of law, that some small sales are not automatically sufficient. And when she says some small sales are not in itself sufficient, she means something different.
Correct. Yeah. We say that.
You
also say
you
that.
say that what she's really saying there is small sales by themselves are never enough.
Yes. Yeah. And we say that because, not only because of that sentence, but we also say it because of the findings of the judgment. If you look at the judgment and the way that things are characterised, they are characterised in quantitative terms. And the law tells us, I mean, the Lemaire case, which I'll also look at, shows that it's can be enough. There was absolutely nothing else apart from the small sales, and that was to an importer to the trade. It was never seen by the public because they weren't sold on. The importer went out of business. So,
Well, I understand what you're saying. Thank you.
So, I mean, it may be simply an error of expression, but we certainly see it as a point of force, and it's also it's different from a summary of principles, which is number 8, where she correctly summarises the principle from the London taxi case / REBA. It's not the case that every proven commercial use may automatically be deemed to constitute genuine use. And we say that is processed as too small to count. And in fact, this was a very common, in my submission, misapprehension of what REBA said. If you look at the REBA case itself, which is at 40... Yes, tab 61 of authorities bundle 6, yes. Right, so Fortunately, these European judgments are quite short. The facts were fairly straightforward. There was a pastry shop that was using the mark, and actually not on the handmade chocolates, but on a little sign next to it. And there was fairly regular but small quantities. And they were successful before the opposition division, and then unsuccessful before the Board of Appeal. If you look at paragraphs 9 to 13, just scan those. The earlier mark was registered for pastry products, chocolate goods, and then the proof of use was fairly scant. It was a written declaration by the managing director, 2 photos of expenses of the pastry shop, copies of the monthly list about the chocolate sales, and extracts from the website. The website, it wasn't a buying or selling website, and it was advertising the shop. It doesn't actually feature in the decision because the Court of Justice says, well, that was all dealt with on the facts by the General Court. We're not going to look at that. But the Board of Appeal, we say, and it's significant the judge cites the Board of Appeal in her judgment, but the Board of Appeal did take this quantitative reading of the law that I've just been submitting the judge did. So, paragraph 12, with a contested decision, the Fourth Chamber of Appeal repealed the decision of the opposition division and completely rejected the opposition. It was of the opinion that the evidence provided by the appellant was admissible, but was not sufficient to prove the genuine use. That's whether the evidence is sufficient. And then the paragraph 13, with regard to the type of goods, and even taking into account the fact that these are handmade, the quantities sold were not sufficient to seriously secure a share in the German chocolate praline market, with the result that the use was of only marginal local significance. Now, the judge specifically name checks the Board of Appeal, and it's clear we say she had that paragraph in mind, but doesn't cite it, to be fair. Now, in terms of the important parts of this decision, this case is about, we say this case is authority for a very simple proposition, which is a proprietor cannot say, because I have shown commercial non-sham use, I automatically win. And one can see that argument being made by the appellant in that case on page 1601, paragraphs 21, 22, 23. So that is the submission of that party. And the court, and the assessment by the Court of Justice is on page 1602, and there's a citation of the important principles. But then it's 32. Contrary to the opinion of the appellant, examination of the genuine use cannot be limited to the mere determination of use of a trademark in business transactions, since it must also be a genuine use within the meaning of the wording of Article 43.2. Therefore, not every proven commercial exploitation can automatically be classified as a genuine use of the trademark, and that's the only principle that comes. It's an important principle, but it's not the principle that the judge summarised. Now, I mean, to some extent, it doesn't matter to this case because we had more than just simply commercial sales. I mean, we had advertising, we had AdWords, and so on, but it is significant, we say, because the judge took a very, very strict approach to the quantification of our material and the number of bookings, which was small, and in effect imposed a test of commercial success. So when I say that the judge referred to that, we say it's pretty clear from the judgment, as I say, that in relation to the quantification of marketing, number of bookings.
While we're on this authority, I think we should perhaps look at the last sentence of paragraph 33.
Yes.
Where the Court of Justice says, taking into account the sales quantity of goods protected by type of characteristics, geographical direction,
yes,
advertisements, continuity use, the court made a comprehensive assessment of the use of this trademark this way, established a certain interaction between the factors suitable for producing genuine use, and therefore it said it was didn't commit any legal error.
Yeah, and that's a point, and that's in a sense one of the reasons why you can't have either a positive or a negative rule in relation to purely sales quantities, because it's got to work with the degree of other material and the relevance of that other material. There's an interdependence one sees in the later general court judgments that refer to this. I'll show you that fruit case.
Do you dispute that the judge did consider all these factors?
No, I do dispute that, yeah.
Okay.
Yeah, I do dispute that. Because the judge, in effect, imposed, it was the scale that mattered. So it was the desultory marketing and it was the scale of use, which if you were to just impose, scale and frequency is important, we don't deny that, but it's got to be seen in the round with the other material in the case. I mean, for a start, she siloed out the EasyOffice.co.uk website, which was advertising Croydon all the time. So we do accept that, but we fully accept that, in fact, I had that down as a paragraph to take my thoughts, because, of course, we say that's the danger in focusing on anything too specific. Although, ultimately, what you are looking for is whether it's genuine or not. And that can happen purely based upon some small level of sales, if it's considered to be genuine. I want to show you the Laboratoire La Mer case.
Before we go to La Mer, just looking at Rebirth, what was it in that case which made the use of the mark not genuine? I mean, it's not. There's no finding that it's a sham in the way that you would normally understand sham, or that it's simply being done in order to maintain the mark. Why did the Court of Justice say that the lower court was entitled to come to the view that it was not genuine? What does genuine mean?
Well, the genuine is defined in the case law as consistent with the creation or maintenance of the market share, consistent with the essential function. It's not equated with a size of operation or scale of operation, although that can be relevant as a factor. In terms of why they denied the registrability, the use, I mean, one can speculate, but of course, as between the General Court and the Court of Justice, there's a very strict appellate principle. And there's the paragraph that my Lord Justice Arnold drew my attention to.
Yes, you take into account all the factors. I understand that.
And
But
they did that.
What is it you're looking for?
So in this case, as I say, the specifics were that there was no branding on the chocolate. There was no, the website, you couldn't buy the chocolate, and the website marketed the cafe, not that particular brand of handmade chocolate, of which there were many that they sold. So imagine it, just happened to be called whatever it was. And that is those were pretty fatal. The quantities, of course, were small. They were quite regular, though, and there was no doubt about them. There wasn't a question about it being made up. It was simply a question of insufficient in that field, and you have to look at the goods in question as well, in that field for maintaining a share of the market in chocolate. It was simply taking into account all the multifactorial considerations, not enough. And we accept that that is permissible. And of course, the La Mer case could have been decided against the proprietor as well, but wasn't. The facts of that case were, I think it was £800 worth of sales in 5 consignments to an importer only of cosmetics, which is a fairly large EU market. And the outcome was that there was genuine use, but I'll take my lords to the judgment. It's important to see.
Why don't we look at that now?
Yes. So that you can find in tab 23 of the second authority. The background to this was a reference from Mr. Justice Jacob, as he then was, with a memorable judgment about unused marks lying in the shipping lanes of trade. But then the rather remarkable result that the ECJ just dealt with it by reasoned order. Didn't even give it formal judgment or hearing. Anyway, the came back to High Court, Mr. Justice Blackburn, who held that there'd be no genuine use. And there was an issue in this case, which also came up in the fruit case, about whether sales to the trade were sales on the market at all. But it was held by Justice Mummery in this that there's clearly a market that can be called a trade market, so you can't necessarily distinguish between the two of them, and we rely on that for the purposes of the proposition we've just been looking at, which is this was a case in which small sales to the market were regarded as being sufficient in all the circumstances of the case. So perhaps to show you the facts, I mean, I think I've probably summarised them sufficiently, but they're summarised at paragraph 10. And then there's a discussion of the various rulings of the Court of Justice at that point, Ansell and Lemaire. And then at 21, there's a summary of the judgment of Blackburn J. And there was this point about internal use, whether use on the trade market is somehow not legitimate, and so on. And then a discussion of token use, and that was not alleged in that case, I believe. Yes, that wasn't alleged. Token use doesn't count, but it wasn't a case of sham use. Now, first paragraph I wanted to show you of Lord Justice Mummery is paragraph 23, which in my submission bears a striking resemblance to the central principle of REBA. Although token use of a mark is obviously not genuine use, it would be illogical to assert that every case of non-token use qualifies as genuine use. Ansell and the reasoned order in this case are clear that even if the use is not token, it's still necessary to consider other factors in order to decide whether or not the use of the mark is genuine. For example, internal use. So what they're saying is, again, it doesn't mean it's automatically genuine. It just means that you've got to find genuine in the light of all the evidence, which may, in that particular case, be sufficient based upon small-scale use. And we see that from the very facts of this case, where Justice Mummery talks about the use by the single importer and concludes, 31, I've reached a different conclusion. Blackburn J interpreted and applied the rules of the Court of Justice, considerably more important on the market on which the mark comes to the attention of consumers and end users. I agree with Mr. Tritton, that was to erect a quantitative and qualitative test, and he talks about the various markets. Significantly also 34, intention is not relevant, it's an objective test, and so on. I wanted to show you Lord Justice Newberger's decision, judgment, if I may, it was, and picking it up at 42 to 44, with particular emphasis with what is said at paragraph 44, if I may. Sufficient in 44 is one of those words that is apt to be misunderstood. Something can be sufficient to preserve or create a market share without being quantitatively sufficient, and Lord Justice Newberger agrees with the submission of counsel that the words sufficient to preserve or create a market share perfectly capable of being read as meaning use which is sufficient for the purpose of preserving, creating market share. fundamentally, it is about assessing the genuineness in the light of other factors other than just, including the quantitative, but also other factors. And it's interesting, we submit what is said about the reasons why that would not be a good idea in 46, 45 and 46, because if you think of genuine as imposing some sort of quantitative level, first problem is that it's not the same word in other language versions of the directive. But secondly, if you, once one imposes a requirement of significance or substantiality, it becomes potentially difficult, time-consuming and expensive to decide whether in any particular case that requirement is satisfied. In this connection, Mr. Tribb made a fair point when he suggested that the introduction of a test of significant use would lead to detailed arguments about the precise nature and extent of the market in which a particular trademark is used, as well as a detailed inquiry in many cases as to the precise nature and extent of the use of the particular mark over the 5-year period. I do not regard that as a particularly desirable outcome. But again, that's not to say that it's irrelevant. The market is important, especially potentially with the EU marks, but it's an assessment of, it's one factor. We say that is what the judge did by imposing effectively quantitative thresholds throughout the judgment was wrong and based on a misunderstanding of REBA in the case. Second ground is that the judge wrongly construed the specified services and thus wrongly held that brokerage is outside the specification. Brokerage, whatever it is called. Now, I need to position this issue correctly so that my lords understand the significance of it. People like Nuclei and instant officers are called brokers. But they're not just called brokers at large, they're brokers of rented offices. Now, it doesn't really matter what they're called, although for what it's worth, we've called them brokers, the judge has called them brokers, and the claimants have called them brokers. But we say what matters for the purposes of the revocation case and the infringement case is what in reality those services are and whether they fall within, for the purposes of revocation, the specified services, and secondly, whether they fall within the specified services for the purposes of infringement. Now, that question is the same in both revocation and infringement in some senses, but of course the facts are slightly different because in revocation, I'm relying on the use that I showed you to say that falls within hire of temporary office space, office rental, information services, office rental, and when it comes to infringement, I'm pointing at Nuclei and saying what they did, which is, as the judge held, pretty similar, falls within, as a matter of identity, the middle of the target, the middle of the bucket of the use that we rely on in those marks. So the issue of construction can be addressed in a number of different levels of generality. The first and most basic way of addressing it is simply to ask, what does it mean as a matter of ordinary English language to talk about a service of the rental of office space or the hire of office space, the hire of temporary office space. But also, one has to bear in mind that a mark is used in many different ways. It is used by the physical provision of the rental space. It is used by the marketing or promotion of that office space, allowing people to search different amounts of different types of office space and so on. And we say that as a matter of ordinary English language, the judge took an unduly narrow view. We also say that the judge failed to have regard to sort of two lines of case law, or she actually referred to one of them, but didn't refer to the other. So the two lines of case law are, first of all, the sort of AVNet read principle, that when it comes to specifications of services, one should look at the substance or core of the service and not hold, for example, that a service is used by all of the incidental ways, things that that service provider carries out. That's the first error. We say the judge actually went contrary to AVNet and read. Funnily enough, a learned friend relies on AVNet and read in order to defend the Jones construction. Secondly, we look at the partial revocation cases and we say that the fundamental approach there is to construe a trademark, of course using ordinary English language, but not unduly narrowly, not unduly broadly, but really how the consumer would conceive of it. Because trademarks and trademark specifications, although they do seem a little bit artificial and strangely worded at times, are intended to be used in trade and are intended to be perceived by consumers and understood by consumers. And that, we say, is a very clear point in our favour, because we have Nuclei itself, when asked what his service was, saying, we have offices to rent. He didn't use brokers when he was talking about what consumers would think of his website. So there are other points, in the sense we've got a certain amount of background nice interpretive material, which we'll show you as well. So if I could just show you the judge's construction. So I mentioned that she had referred to the construction in the infringement section, but had not actually construed it in the revocation section. Nothing turns on that. We've just got to look forward to see the particular construction by the judge. If it's so it's 299 to 301 is the sort of cross-reference forward. Paragraph 299, tab 20, full bundle. And this is talking about Nuclei's business on the hypothesis that that's the same as the EasyGroup business. Nuclei's business does not fall within the hire or rental of temporary office space. It does not itself hire or rent office space. Rather, it acts as a broker for the rental of serviced offices, providing search facilities for potential consumers to find office rentals provided by the companies listed on Nuclei's website. Now, this point has a slightly more force in the revocation issue than it does under the infringement issue, because it's significant under the infringement issue is we say there's double identity, identical mark, identical services, but if we lose on that, we still have a likelihood of confusion because it's similar. But with the revocation, it's all or nothing. It either falls within the service or it doesn't, and if it doesn't, then there's not use of it. So you can't save a mark by similar use. It's got to fall within it. But we say it clearly does fall within it. This brokerage terminology is not visible to the consumer. It's not understood at all. You will have seen the EasyGroup website, the EasyOffice website, offices to rent. It's all very clear that this is use in relation to the hire or rental of temporary office space. Now, it appears, we say, that the judge is taking an unduly narrow approach. If you look at 300, the judge accepts that it's related to the activity of hiring or renting office space, but relies on Skykick for the principle that that's not sufficient. And then 301, in my submission, goes even further to say that it's not an ancillary feature of the rental of office space itself, but is a different service entirely. Different service entirely. Now, this is, we say, quite remarkable because this is the principal way that offices are provided or advertised to the public in the country. So this is how office space is advertised. There isn't any dispute that this is the case, that it's extremely popular and significant form of commercial model for bringing office space to rent before the public eye and then getting them to transact with it. So whether the actual offices are rented, I mean, it's quite difficult to know what the judge means by itself hire or rent office space.
Yeah, what is the distinction in your submission that is being drawn? I mean,
It's quite difficult.
the starting question is, what does the word broker mean?
Well, broker is
Does it
someone...
mean anything more than agent?
Probably not. And on that, I want to show you the EUIPO materials in the TM class, because my learned friend is relying upon the EUIPO guidelines for a reason I'm not entirely sure of, because in my submission it supports my case quite clearly by making it clear that there's no such thing as a broker per se, or in a vacuum. A broker has to be a broker of yachts, or stockbroker, or whatever it is. And in this case, it's a office rental broker. So I've got the right bundle. Here it is. Yes, sorry, it's bundle 6. And I think my learned friend's relying on the EUIPO guidelines, which are there. Yes, it's 76. These are the obsolete ones. Ones that line up, the obsolete. They're of course the relevant one. Now, my lords will be aware that the EUIPO guidelines are of absolutely no binding effect. They are simply a view by the office, who is routinely appealed successfully before the general court, of the law. To the extent they're consistent with the law, they are fine, but to the extent they're not, they're to be ignored, and the general court doesn't regard them in any way as binding. 611 is the passage I wanted to rely on, so it's 1763 is the page number. Brokerage services are services provided by an individual or company whereby these latter buy and sell commodities for a fee or commission. The fee may be charged to the buyer or the seller of the commodity. The broker may never see the goods or services in question. In my submission, this is jargon when applied to this particular sector, because, of course, Nuclei and EasyGroup do not purchase the office space or rent the office space for the searcher, but they do advertise the office space on behalf of the provider. Now, the provider themselves might be a company that, whether they own the specific office space is another matter, as an unexplored area. But we say it doesn't really matter, because all of these brokers or brokerage, it's clear that you've got to put brokerage of name and address based lists, also databases, stockbroker, brokerage of future, carbon offsets, brokerage services relating to distribution, transport and storage. So it's a sort of, it's parasitic upon the particular service in question. As my Lord Justice Arnold put to me a moment ago, it is essentially agent. It may fall within that definition, broadly speaking. And let me show you another document which I think my submission sheds light on this. Tab 79 is an extract from what is known as TM class, which is a database of terms agreed by a very large number of intellectual property officers around the world. And there's a system called the TM class taxonomy. And this is a way of assisting people uniformly to apply for terms in different countries and different languages without too much inconsistency developing. I did extract this in my skeleton, which it might be better to have a look at, because this graphically doesn't quite show it. But what is clear from the version of my skeleton is that rental of real estate and property is an umbrella term with agencies or brokerage for leasing or renting of land as a specific term within it. And that's the submission that we absolutely make. We say brokerage, which is not a term we shy from, a bit grand sounding for what they do, which is essentially advertising office space, and not really acting on behalf of buyers. At least maybe sometimes they do. But as a matter of pure language, we say brokerage with the activities of covering, the activities being carried out fall within the term. Let me show you the skeleton just so you can see it a bit better. It's not abundantly clear from that one. Tab 12, page 70, and that's a printout from the actual website. Now, I'm not sure what the answers to this in his skeleton. It said, well, that could be out of date or wasn't the version in force at the time. I'm not aware that there are any versions of TM Class. It's simply an initiative prepared by the Joint Intellectual Property Officers ongoing. And if you put in broker, that's what you get. Now, we accept that this wording is not exactly the same, but it shows the principle that rental of real estate, well, that will include offices, and property will include offices. So rental is a subsection of real estate services, that's uncontroversial, and then a sort of subset of that would be agencies or brokerage for renting land, buildings, which would be offices. I mean, they don't have the specific terms at issue in this case, but the principle is quite clear that it would fall within it. So to hold that there's it's a completely different service, not even ancillary, we say is a wrong construction. I just wanted to show you some of the case law very briefly. I'll try and maybe just bring one or two examples.
Can you help me with this, Mr. Melody? I don't myself feel any difficulty distinguishing between two services. One is the hire of rental of offices. That's done by a landlord. Another service is finding landlords for customers. That, it seems to me, can be properly described as a different service. But is that the beginning and the end of the question, is what I'm wondering? Because when one's talking about use of a trademark, one's talking about use in relation to services. And the question then becomes, does somebody who finds tenants for landlords, do they, using a particular mark, do they use the mark in relation to the rental of property?
Yes.
That seems to me a slightly separate question. I mean, to say that you can't possibly say the services are different seems to me to be wrong, but then it may not be the full extent of the inquiry that one
Yes, I think I do embrace that as an alternative. I say they're either the same, they're falling within, but if they're different, they still fall within that broader term. So there could be different services within it, in the same way that information services would be different from, might be said to be different from rental of property, but might also be said to be a subset of that, to the extent that it is use in relation to that. So yes, they could be, strictly speaking, Croydon and instant officers could be different services. I wouldn't want to call them different services, I'd call them subsets, different subsets of the same service of office rental or the hire of temporary office space. In general, trademark specifications do not distinguish between different models. Service is a service, and it's here. The key purpose, which we say is the important criterion, is the hire of office space, or rental of office space. And of course the acts, and this may be also an answer to my Lord Justice Floyd, the acts themselves are numerous and specified in the directive and our legislation. Fixing the mark, using it on business papers, using it in advertising and so on. And that's where you can start to find different forms of use. I think perhaps the artificiality of this might be because I'm trying to combine the infringement analysis and the revocation analysis. They're not necessarily the same. Yeah. All that matters is that the use is seen as a reference to, or in relation to, the offices of offices to rent, and that's the position. So perhaps I won't turn up. I'll just very quickly turn authorities tab 16. Sorry, authorities tab 34. Which bundle is it? Sorry, it's your one. 3. Which is bundle 3.
Which bundle, sorry?
Bundle 3 of the authorities bundle. It's a judgment by my Lord Christopher Floyd at first instance, and it's important not to go overboard with the considerations raised by my learned friend about trademark monopolies and having to know exactly where the border is and where the public policy lies in terms of certainty. We accept all of that. But by the same token, you shouldn't go in the other direction. In this case, it was being alleged that telecommunications had a sort of buzzword meaning. It meant the large telephone companies or the telecoms companies and so on. And here the judge said that there are sound policy reasons for not interpreting them too broad, and that a liberal interpretation, if you look at 12, the limits become fuzzy and imprecise. But nevertheless, the principle should not be taken too far. Treat was decided the way it was because the ordinary and natural, or core meaning of dessert sauce did not include jam. Each involved a straining of the relevant language. But where words and phrases in their ordinary natural meaning are apt to cover the category of goods in question, there's equally no justification for straining the language unnaturally so as to produce a narrow meaning which does not cover the goods in question. And it's often sort of, Lord Justice Jacobs' statement, dictum in the Avnet case is of course perfectly apposite, but it is also important not to go too far in the other direction. We say that the substance or core of office rental is the purpose of office rental, and that can be a number of potentially different services within that term, or services that are in fact the same service just provided at different points in the chain. I mentioned that there was some authority for what the consumer thinks being important, and that case law that comes from the partial use line of authorities, and there's 2 Court of Appeal judgments and another judgment by Lord Justice Jacob. It suffices to look at the freestyle case, which I'll just find for you. It's tab 18. Bundle 2. Yeah. Now, this case, like others of this kind, are concerned with whether the use of the mark is narrowly within the specification and should be rewritten to the extent it should be, what is the appropriate language to adopt. The point, as I say, almost came up in this trial. In fact, we had a number of submissions in our opening skeleton on partial revocation, which, but because the defendants were successful in showing that what we had done by advertising office rental was completely outside office rental, there was no need to get into partial revocation. But the principle is, we say, analogous in terms of understanding what consumers make of a trademark and the importance of consumer impression when it comes to a fair specification. And the basic test is that what would the consumer, understanding what is the purpose of a trademark specification, what would a consumer make of the use and how would they describe the use? What would be a fair level of generality? And that test is found in
493, power 57.
Yes, there was a point before then. Just to frame it, it's paragraph 22. The question here was whether there was something that the consumer understood called land-based holidays, effectively, because it mattered whether the specification would be partially revoked away from the defendant's use. And the actual test comes in later. It's 597. There's reference to the decision of Pumphrey, J and Deacon, which is that the court's task is to arrive at a fair specification having regard to the use made. In my view, the task should be carried out so as to limit the specification to reflect the circumstances of the particular trade and the way that the public would perceive the use. And we see that test is developed, and it's really the whole passage there, but 39 is the sort of conclusion paragraph. How would the average consumer describe the services provided by Thompson under the freestyle mark? I believe they'd use the term package holidays. That term is a fair description. You will have seen in the skeletons and in the defendant's attempt to contextualise what Mr. Abraham said, when asked an open question in cross-examination, how would the public describe your use? He said, we have offices to rent. We said that's a very clear indication of how the public would see it. And what they're saying is searching, officers being able to search for offices, being able to compare offices, being able to find office space. And that is, we say, absolutely paradigm form, an exemplary form within the specification. So that, we say, is the essential. I've got slightly more points to make on construction when it comes to infringement. Not a lot, not a great deal more, but I'll turn now to my third round on revocation.
Can I, just before you leave that point, pick up what
Yes.
my Lord Sir Christopher Floyd said earlier? The average consumer who goes onto the website is going to understand by the end of a transaction that in most cases it's not EasyOffice themselves that are offering this. It's not their own space. They're offering other people's spaces.
Yes.
Because when you click through, that will become.
I think the suggestion was you have to telephone, and we don't know how the telephone was answered. But in any event, it's accepted common ground that instant officers administered the arrangement of renting office space. So,
But the average consumer will appreciate, will they not, the difference between the two services that my lord referred to. There's a difference between a landlord offering space which can be rented and somebody who is basically, you don't like the word broker because you don't think that's a consumer word, but a middleman
The middleman's fine. We don't dislike the word broker. We use it ourselves.
Well,
and the judge found it to be.
Yes, but you
It's
described
more
it
because
as
it doesn't tell us
jargon.
very much.
You said it was jargon,
Yeah.
which tended to suggest it wasn't a consumer-friendly word.
It isn't used. There's no evidence used by consumers at all.
Does it matter? Because would the average consumer not appreciate the difference between you're acting, leave aside the Croydon offices, but in the instant office case, you're acting as a middleman.
Yes.
The consumer appreciates that.
They would understand. I think the judge was persuaded by the fact that Nuclei, in terms of the infringement, offered lots and lots of office space and couldn't therefore be the owner of all that space. To accept that. But so far as the EasyGroup use is concerned, of course, that was embedded with use by EasyGroup in relation to their own premises, Croydon, most importantly, but also prior to that, Old Street and Wimbledon. And the assumption wouldn't necessarily be made. They're not the kind of outfit that are necessarily offering other people's offices, so to speak. But it doesn't matter. I say that even if it is a different service, it doesn't have to be the same exact service as providing office space. By the way, providing is another bit of jargon. The office provider or operator is the one who actually owns the offices or whatever it is and rents it out, so to speak. It doesn't have to be the same to fall within the term temporary hire of temporary office space or rental of office space.
How do you say the average consumer would describe the services provided by you under your mark?
So if they were, I think there's a reference to it in the W3 case where Lord Justice Arnold considers these. Providing information about office space, providing searchable office space, providing a website, allowing consumers to book or search for office space. And all of those fall within hire of temporary office space or rental of temporary office space in my submission because of the generality of the words. And that's supported, of course, by the TM class.
So I'm trying to understand what the question for us is. Is the question, would the average consumer describe what you did under your mark as the hire of temporary office space? Is that the question?
Well, it is to some extent. The trademark specification terms are apt to be very broad and sometimes artificially so. So, for example, land vehicles in Jaguar Land Rover. No one uses that term in commerce, but as a matter of construction, it includes all the different kinds of vehicles that you can get. And that's what I'm talking about. I'm saying that the term office rental or temporary hire of temporary office space involves all of the businesses and the different business models that are involved in providing that service. Now, there comes a point where they are potentially providing something different, completely different, but they are also providing something that shades of difference to each other as well, but still falling within the umbrella.
I'm sorry to interrupt you, Mr. Malich, but as I understand the questions my lords are asking, they are trying to distinguish between two different questions. The first question is what services are being provided by someone and how the average consumer would describe those services. And then the second question is in relation to which service or services was the trademark being used? Now, we'll have to wait to see what Mr. Van Heegen says in due course, but I assume that it won't be disputed that someone somewhere was renting an office, because otherwise nothing could happen.
No.
Now, if that is accepted, it may be that we don't need to get into too much hair splitting
about precisely what service your clients were providing if there was use of the trademark in relation to hire of the officers.
And
Now,
yeah, I think
therefore, the question is that part of the way in which you put your case, that distinction?
it is.
And secondly, to what extent that's the right analysis?
So that is my third ground. That's use in advertising, because the advertising use is advertising officers for rent, and that's a use of the mark in relation to officers for rent. Put simply, and perhaps I should have moved that one up the list, because construction, it isn't quite rightly a matter of trying to call my use something, although it's helpful, it may be helpful to understand it and crystallize it. If I am doing little more, and we say Nuclei are doing little more, than advertising office space, advertising the hire of office space, even if someone else is actually doing the renting. Now, use in advertising, we say, first of all, under the tab 1 of bundle 1 of the authorities is Trademarks Act, pursuant to the Trademarks Directive, and section 10 I wanted to take my orders to, which is page, the tab 1, first bundle of authorities, page 12. And this has been applied in the revocation context as well. These are the infringement provisions. Then over the page, it's got section 10.4. For the purposes of this section, which has been read into other sections, a person uses a sign. In particular, he uses it on business papers and in advertising. Now, of course, to infringe, you would have to be use in relation to the relevant services, and we say this is use in relation to the relevant services. And I wanted to show you an authority which has brought out this point particularly. I mean, this was always relied upon at trial as being use. There's always a slight difficulty with advertising and making sure what it is it's being advertised. And we say, in this case, there was no doubt, but sometimes there can be. If you take the case of Standard International, and sorry, that's all I wanted from the Trademarks Act. There is a bundle 6. It's a bundle of authorities number 6, the European Union case law, relatively recent case. This is mine. And it's tab 71. Now, this was a case where there was an EU trademark obtained, as you can see from the head note, for goods and services in class 18 and other things, but materially for hotel, restaurant, lounge services in class 43. And the issue was, as you can see from the head note 14 on page 1710, even if the applicant supplied goods and services outside the European Union, it was conceivable that the applicant would make use of that mark in order to create or preserve an outlet for those goods or services in the European Union. And that really is the key issue here. See, my junior was involved in this case. The paragraph 4 is a simple list of just wanted to show my lord the evidence in the case. Yes, it's paragraph 10. As regards the place of use, the Board of Appeal pointed out that considerable amount of the evidence concerned hotel services and ancillary services provided by the applicant in the United States. Among that evidence, the Board of Appeal noted various documents referring to advertisements, promotional campaigns aimed at customers located in the EU, reservations made directly by customers and through travel agents situated in the EU, invoices addressed to customers, and so on. There's Google Analytics and so on. But the key point was that all the hotel services as such were provided outside the EU, so were sort of out of scope. And then I think probably pick it up at probably a lot of sidelining, but I think probably 32 is sufficient. And if I could just perhaps ask my lords to read that. And then 34 down to 34. And then 35, and then the last one would be over the page, 41 and 42. So, use of trademark demonstrated by multiple types of acts. And there's reference to the use of in business papers and in advertising. It's quite an extreme case because the actual service is not provided in the jurisdiction, but the ancillary.
Yes, but the point of the case is that the place of provision of the service is irrelevant. What matters is where is the trademark used. If the trademark is used in the EU, then the fact that the service is provided outside the EU doesn't matter.
Exactly, and so
But is that relevant for our purpose?
well, it's the jurisdictional point isn't, but the fact that the advertising use can be a separate act validating the use is relevant. And we say that is, in a sense, addressing the point that's been occupying my lords for last half an hour or so, which is that the if there is a disparity between the types of use, then the advertising use can stand on its own to some extent. Whether you call it searchable, bookable, or brokerage may not be important. The consumer sees that as an advertisement, which it undoubtedly is, for a large amount of office space, and therefore it is use.
All right.
Certainly,
Can I just ask this question? Is this the same point, or is this a different point? Because on one level, I would assume it's not disputed that advertising can constitute use of a sign and therefore use of a trademark. But the question here is not whether it can, but whether there is genuine use of the relevant mark in relation to the relevant services.
it wasn't disputed, and in fact the judge found that it's mere advertising is not sufficient. So it's one of these rules where you've got to take into account all the facts and matters. Mere advertising may be sufficient. I'm going to show you a case in fruit where that was all there was. There wasn't sales, and it was on the circumstances of that case sufficient. The judge here held that the website use, without details of the transactions and all the details of the instant officer's arrangement, simply was not sufficient, or was qualitatively not the right kind of use. So we said that was wrong in principle. Maybe at that point I will just quickly show you fruit, although the danger of these cases is one inevitably sort of starts to rely on them for their facts, and that's actually not why I was going to go to it. Let me just the timer. perhaps finish revocation. So just checking this up. And so then this little came after that, but they more or less say the same thing. To have 62, so it would be the same bundle that we just had. And this was trademark was fruit. You can see at the bottom, the goods were clothing. The company was Fruit of the Loom, so there was an issue with the extent to which they had used fruit when they used Fruit of the Loom, but also whether they had used fruit independently in relation to clothing. And 8 is a paragraph which gives an idea of the actual use made. More specifically, that although the mark fruit was affixed on small labels stitched onto the goods, the primary brand present on the Born of the USA range was the Fruit of the Loom mark, as was evident from the title page of the catalogue, from the range, and from the photographs at the applicant's stand at the Bread and Butter Fashion Trade Fair, which took place in Berlin. And that was the issue in this case, that there was a trade fair and that the use that was made was essentially only promotional use at that trade fair. And that during the 5-year period, the applicant, so the proprietor in fact, decided to discontinue that use. And so, and that was still, didn't prevent it from being genuine, but that's the facts. But I wanted to show you the summary of the case law principles, and I think my learned friend's Lidl authority is very similar to this. You pick it up at paragraph 18, page 1611. This is
well, this is all familiar principles.
all familiar principles, but the point I did mention that there was a sort of ground relating to the continuum of use and the commercial success and the attributes of the proprietor, and that's where this point comes in. If you look at 24, you can't rely on probabilities of suppositions, fine. And then 25, as to the extent or scale of the use, account must be taken of the commercial volume of the overall use, as well as the length of the period during which the mark was used and the frequency of the use, so far uncontroversial. The turnover and volume cannot be assessed in absolute terms, but must be looked at in relation to other relevant factors, such as the volume of business, production or marketing capacity, or the degree of diversification of the undertaking using the trademark, and the characteristics of the goods or services. It need not be significant to be deemed to be genuine, provided it's justified, no a priori, so on. And then 27, the purpose of this exercise is not to assess commercial success or to review the economic strategy of an undertaking. Now, I think the learned friend will want me to refer to the next paragraph. The smaller the commercial volume of the use, the more necessary it is for the proprietor to produce additional evidence to dispel doubts as to the genuineness. We say, in particular in relation to Croydon, there wasn't any doubts. The material was all there. Happened, was assessed. Now, the judge in this case basically compared the marketing that had been spent in relation to Croydon with the marketing that was spent in the heyday of the business.
Sorry, I thought you were taking us to this authority on the question of advertising.
Oh, sorry,
as a
was
pure
so,
basis.
so quick I didn't.
use.
I perhaps didn't dwell on it long enough. That was the purpose of showing you that this was a case in it's 12. Sorry, if I could just ask you to read that to yourself. That was the legal principle. I'd already moved on to the next one, conscious of the time. I may go briefly into after lunch on revocation. if I could just ask you then to read paragraph 12.
Paragraph 12 is reciting submissions, is it not? Have I misunderstood?
Perhaps that's right. As regards the extent of the use of the cancellation division, I'd read that as the summary of what happened at the cancellation division, and then recitation of case law. But maybe that's right.
It's reciting the submissions before the Board of Appeal.
Before the board.
Yeah.
I've not understood what help we get from paragraph 12. I'm being very slow, I'm sorry.
No, my lord is absolutely right. There was another paragraph where this is. Yes, I think maybe it's 54, 55.
Yeah, it's
So-
really 55. Isn't it?
Yes. And so, I suppose down to the 8. And then, in fact, the extremity of this case can be seen from 61. Nevertheless, that does not exclude the possibility that a decision by the proprietor of the mark to not launch goods covered by the mark on the relevant market may, depending on the circumstances, be taken into account for the purposes of assessing the genuineness of the use invoked. Such a decision may constitute a factor. So the fact that you advertised, it didn't work out, and then you decided not to continue or to launch, that's not necessarily lacking in genuine use. I mean, that's really, in my opinion, it highlights the sort of, really the question that's looking is the target is genuine use, and that can be assessed in a multitude of different ways. Sorry, I was relying on this also for the point about commercial importance, and so if you look at 63, it cannot be found that a proprietor of a mark which has invested considerable material and human resources in preparatory work for the launch of goods protected by the mark, assessed in relation to the economic importance of its overall commercial activity and the nature and the size of the relevant market, has made only token use. The fact that the proprietor of the mark took a commercial decision to postpone or stop the launch should not constitute the only determining factor. I was showing you earlier the significance of the size of the market and how it shouldn't be assessed in absolute terms. And we say that, and shouldn't be a test of commercial success. Now, we say that's exactly what the judge did here. In two respects. First of all, she looked at a report put in by the defendants to say, well, your market share is tiny, which is, we don't say that that's completely not allowed, but it can't be, it was another qualitative factor. But more importantly, in the judgment, the judge relied upon our previous success to penalise what we were doing now as being not genuine, when in my submission, if anything, it would have suggested that a more forgiving approach would be appropriate, because if one is looking for a business that has already been successful and looking what it does, that's very different from a completely new party. Let me just explain what I mean. Imagine if Croydon was embarked upon by a completely different party, and they had done only what was done in Croydon, right? Put a photograph of themselves on a website saying, come to Stavros's Easy Office and done all those things. Well, that would be very different from Sir Stelias doing it in relation to a business that had considerable success and considerable sort of residual goodwill and so on, and family reputation. In my submission, that makes it more, not less likely to be genuine use. And yet the judge held that that was a point very much against us. You can see that from the revenue discussion, but also 271, where she says the Easy Office business was not a new entrant in a niche sector. It had been in business since 2007 as part of a very successful family of brands. An Instant Office's report stated that in the UK alone, 31 million square feet of service space was available, and the revenues that were generated by this business don't come close to showing genuine use and desultory marketing effort. So it seemed in our submission, it's quite clear that the use was assessed in principally quantitative terms and by reference to an absolute view of the market, which is also wrong. And if one thinks about it, if I opened up an office premises just as a new entrant to the market, I might only have one office. I might have one suite of offices. In fact, the evidence in this case was a submission that the judge rejected, that even if we'd had full occupancy over 2 months, we would have made a revenue of £6,700, and we were spending £2,000 times 2 per month over 2 months on Google AdWords. So that is, you've got to look at the characteristics of the proprietor, but you've also got to be realistic. It's like you can't say that because they're effectively EasyJet or as big as EasyJet or part of a huge family of brands, that their commitment to this particular product is going to be so high. That's what the Court of Justice means by taking account of diversification. This is a diversified business, and this specific aspect of it was relatively unsuccessful, or failed. It failed. We make no bones about it. It failed commercially. It was very successful at the beginning. It failed during the 5-year period, but there was genuine use during that 5-year period, and the judge was wrong to have revoked it back within the period that she did. So far as the final ground of appeal, and I can hopefully conclude, I'll deal with that very, very briefly. The judge held that the use made by Nuclei, and by implication Easy Office, was information services for the purposes of, strictly speaking, information services relating to rental of offices and relating to hire of temporary office space. And then revoked it back to the rump as if it had never been used. That is just there is no warrant for the judge having done that. It was clearly pleaded as being use that relied upon in the amended particulars of claim in the Part 18 request, which served the amended particulars of claim, and which was dealt with in the reply and defence to counterclaim. All of the use could be characterised as information services, and the judge went on and specifically considered that from an infringement point of view, and it's difficult to see why EU 376 wasn't saved on the alternative basis. But as we say, we strongly contend that the use that I showed you, taken in the light of the